Hey everyone, I'm back. You guys are gonna get sick of seeing me because I'm been on more than I planned. But I said that I would come back and discuss the motion if I got a copy of it today. So that is what I'm doing. I'm just waiting for some of my people in my group to get here. It'll take a minute, I'm sure. I see a few coming on now. I know this is a different time. This is a little bit earlier for me than normal, but some people were upset that it was so late all the time. I can't really win there. So I'm just trying to, this just happens to be the best time for me today. So, okay, well, I'm going to get started. You're not late today. Okay, so the first thing, I just want to mention first that, I don't know if it was the last video or the one before, I've lost track already, but I did say something about, KZ's brief being due 6 days after it's in the Court of Appeals. Yeah, that was before it was remanded. I don't really know where my brain is sometimes. I do tend to get very nervous and a little confused. Hey there. Hey ladies. So that was the case. But if this goes back to the Court of Appeals after the entire thing is done with the supplemental motion and everything, if it has to go back to the Court of Appeals, which we'll talk about later, it would be back to being 40 days before the brief is due. I actually put some dates down today because somebody asked me about it. And if everything goes to its longest date and the judge still denies everything and it goes back to the Court of Appeals, that would mean KZ's appellant brief should be due around November 5th. I just threw that out there because, somebody asked me about it today. But the supplement is due on July 9th. And this motion for substitution, if it's denied, that shouldn't affect anything. If it's granted, then it could delay things because a new judge would probably need some time to get up to speed. So that might change things. Okay, so the first thing I wanted to go over today was the fact that I know yesterday when I was talking about this, I said that a substitution for a judge has two statutes, a civil and a criminal. Okay, I was talking about the criminal statute. And I took a little flack for that this morning once it came out and she was filing it under the civil statute. I want you to know that there is a method to my madness too. Okay, first off, I am well aware that under 97406 it is handled like a civil proceeding. Okay, and I did consider the fact that maybe it would fall under the civil statute, but I wasn't really sure. And the one thing that made me think that maybe it fell under the criminal statute was that I know the one case law that I do know, or some case law that I do know, is that there was a case about 9 years ago, and it was very confusing because the defendant in the case had asked for a motion for a new trial. Okay, now if you remember back when Kathleen filed the original post-conviction motion for Steve back last June, she filed it under 97406. And then she filed it under 80515, which is a motion for a new trial in the interest of justice, stating that the controversy had not been fully tried. Okay. Well, about 9 years ago, there was actually a case where somebody tried to file a motion, a criminal defendant tried to file that motion. And the state had argued that that is not a criminal statute. That is a civil statute. And of course, the defense was saying, no, it can be used in a criminal case. The circuit court denied his motion and it went to the Court of Appeals. And the Court of Appeals actually didn't know what to do with it. They were confused themselves about the statute. So to anybody that wants to give me a hard time, if I occasionally misinterpret something or get confused, even the Court of Appeals gets confused sometimes. They weren't even sure what to do with it. So what they did is they certified it to the Court of Appeals. Now, when a case is certified to the Court of Appeals, that means that they're asking for help. They're saying, like, we don't know we don't know what the statute is saying exactly either. Can you clarify for us before we rule? So the Supreme Court of Wisconsin actually wrote a very lengthy opinion on this because apparently it had been something that had been very confusing for a long time. It seems like it's something so simple, but they actually declared that it is in fact a civil statute. And in their opinion, they had talked about how this civil statute did not apply to a 97406 proceeding, which is supposed to be civil in nature, so you'd think all civil statutes would apply, but that's the case I remembered when I was thinking about that. And so if they're saying that civil statute doesn't apply, then, you know, maybe some of the other ones don't. I think I was thinking in terms of the 97406 following civil appellate procedure, and not so much every civil statute. Okay, so I, you know, could be wrong, whatever, but that was my thinking at the time. So I'm just trying to explain why I thought that. It's not because I'm an idiot, contrary to some of the comments I saw this morning. But no, it's not. It's just that, I mean, there actually was sound reasoning to why I was thinking that. So now going back to Kathleen's motion. So she did file it under the civil statute. Okay, and I have the motion here, and I'm gonna have to read through it because I didn't write any notes down, which, I don't know, good or bad. Okay, so the civil statute says, and I won't read the whole thing, but I think I actually have to get to it first. Okay, she's filing it under, well, first off, okay, one of the differences between the civil and the criminal statute, the criminal statute, when it comes to appeal, it says that when a appellate court remands it back to the circuit court upon ordering a new trial or a sentence modification, then a substitution can be requested. And it pretty much ends there. Okay, so the civil statute is a little bit different with its wording, which is another reason why she probably really wanted to use this statute. So it says here that if upon an appeal from a judgment or order, or upon, well, don't even worry about that part, the appellate court orders a new trial or reverses or modifies the judgment or order as to any or all of the parties in a manner such that further proceedings in the trial court are necessary, any party may file a request under this subsection. She also cited the subsection 1, which just says that you just have the right to do it. It's considered like a peremptory thing that you get, just like a peremptory strike with a jury. You don't really have to give cause, whereas in the criminal statutes, you get one in the beginning of a criminal proceeding, but after that, you would need to show cause or need to show prejudice or bias, which was a big conversation that we had yesterday. Was that what could she possibly show bias or prejudice? And I kept explaining to people that, you know, you really can't. We don't like the judge's decision, but it hasn't been ruled on yet whether it was wrong or not. So I'm going to be going back to that later, but I want to go through what's actually in the brief first. Okay. The key thing in this brief, everything that she's putting everything on in this brief, oh my gosh, this motion is the further proceedings. She just kind of forgets about everything else after that and just focuses on further proceedings. And she cites one case, which is a civil case. And what happened in that case, it's a breach of contract case. Boring. But what happened is that they had actually won on appeal and it was remanded back and they asked for a substitution and they were denied and it went all the way up to the Supreme Court. And the sticking point for them were two specific words. And this is where it probably got really confusing for people trying to read this motion. It looked really confusing when I first looked at it. And then I was like, oh, it's not so confusing. It just sounds confusing because, you know, Kathleen's a lawyer. Sorry, Wendy, but you lawyers tend to do that. So in that case, the wording was very important as to what the order from the Court of Appeals was. There's two different categories, whether the Court of Appeals ordered a specific action or quote unquote further proceedings. Now, if they order a specific action, then you do not have the right to a judicial substitution. If they order further proceedings, you do. And it took about 4 paragraphs to describe it. But the difference is that if the Court of Appeals orders a specific action, you're not going to be, or the circuit court is not going to be modifying the record. They're not going to be doing any fact finding. They're just doing something specific. That's it. But it's nothing that's going to alter the record or anything like that. And they say you don't need a new judge for that. And there's no discretionary decisions involved. You definitely don't need a new judge for that. For further proceedings, what falls under that category is anything that would require a change to the record, any fact finding, and most importantly, a discretionary decision by the judge. And in that case, you have a right to a judicial substitution. That is pretty much the whole bottom line of the motion. So she's saying that since the Court of Appeals remanded it back to the circuit court and she's filing a supplemental motion and she's hoping to get the record changed and there will be a discretionary decision involved, it constitutes further proceedings and therefore she should be able to get a judicial substitution as a matter of right. So does anybody have any questions so far about this, what I'm saying? This is one of the reasons I actually still like doing them in my group and getting immediate feedback, because then I understand if I'm actually making sense or if I'm just making it more confusing. And I don't really know if people were able to understand all that just reading the motion itself. But I know it can be confusing, and sometimes people just tune out after the first paragraph and you see all this case law, or not even all this case law, but just these statutes and all these numbers and all this weird wording. And okay, so she also has asked to move it back to Manitowoc County, which is something I was told was going to happen, and I kind of was like, no, I can't believe she's going to do that, but she did. So I didn't really want to say too much about it. I did mention it in my video that I'd heard that she was going to do that, and in fact, she did. She didn't specify which judge. I'm trying to remember. Somebody help me out here, because I know that Rohrer is still there, and I know Dwayne's the new judge. Why am I drawing a blank on who the third judge is? Somebody look that up for me. What about Manitowoc reason? Well, her reasoning was that everything's in Manitowoc. You know, so that's her reason. I don't know why she thinks that. I mean, maybe she knows something. Oh, Joe, you're ruining it for me. I was getting to that. I was trying to save that to the end so people wouldn't get mad at me. Okay, so yeah, somebody just posted what I was going to say about my opinion on this motion, unfortunately. But I was going to get to that. I wanted to cover this other stuff first. But I can't remember who the third judge is right now. I am completely drawing a blank on that, and I should have looked it up before. And because Fox is gone, Willis is gone. Somebody, like I said, somebody Google that and see who the third judge is right now. I'm gonna just kick myself when it comes up or someone says it, because I'm just gonna be like, duh. But you know, I've got a lot in my brain right now with all this stuff. Okay, so what Joe just said, and what ruined everything. No, he said, I think there's a problem because Joe is an attorney, by the way, so he actually is an attorney. He said, I think there's a problem because the appellate court hasn't made any decision on the original order. It hasn't modified it. It's simply ordered further proceedings. Bingo. To me, that is the problem. You know, I mean, she was very clear about further proceedings, and the Court of Appeals did order, you know, further proceedings. But the problem is that the very beginning of the statute, the very first words in the statute, or not the first words, but it says, you know, if upon appeal from a judgment or order, the appellate court orders a new trial or reverses or modifies the judgment or order. That did not happen. There is no ruling at all yet from the Court of Appeals. And the case that she cited, Findor versus Milwaukee, that actually did have a decision, and then it was remanded back. Every case I found had a decision and was remanded back. I looked and I looked and I looked, and I had somebody who was so patient with me that has a Westlaw subscription trying to help me search to find something that would give me some support for not needing it to have that decision. And this is why I said that it really didn't matter which statute overall, because they both say that there needs to be a judgment from the appellate court before you can get a judicial substitution. And that was the thing I said in the beginning, that it made sense to me, because the reason that usually is because you're still in the middle of the proceeding. You're still in the middle of the action. And this is the part where I just beg everybody not to hate me, because I don't want it to be this way. And I'm just reading what the statute is. So, you know, you read the statute again, go look at your copy of this one and you read it again, and keep in mind what it's saying about there being an order or a new trial or a modification of a judgment or order. And you interpret it how you like. I'm not going to tell anybody what they think about it. I know some people emotionally just want to believe that, you know, he's always going to win every motion. And I would love that too, but I am just presenting the facts here. I'm just reading the statute and what I personally think could be a problem. Doesn't mean I'm right. I hope I'm not. You don't, I mean, the thing is that people don't realize that I hope I'm wrong. I hope I'm wrong a lot. about a lot of things. I really do. So does anybody have any questions about that? Because I am going to talk about something else. Does anybody have questions about that specific portion of that? Again, I can never tell if the comments just stalled or, okay. What should have been done then? Well, I mean, nothing else has to change. It was just the fact that I didn't think she could substitute a judge in the middle of the appeal because there has been no judgment yet. It's still considered part of the same proceeding. I have to hit more on that. Yeah, Roar. Oh, Bendix. I said that I would feel dumb. Yeah, okay. I remember the new guy, but I forgot about Bendix. Yeah, she didn't specify which one of the judges. She just said any of them. So I'm not sure she'd want Roar, but and maybe Casey knows something about these judges that she feels like she'd have a better chance in front of them. I don't really know. She has her reasons. What did she mean when she says that the original issues that were in play and aren't now? Did she say? I don't remember her saying that. I thought she just said that it made sense to move it back to Manitowoc. The record, evidence, and many of the witnesses in this matter are located in Manitowoc. All pleadings are filed with the Clerk of Circuit Court of Manitowoc. In short, at this juncture, holding further proceedings in Manitowoc before a Manitowoc judge would be the most efficient use of judicial resources. Oh, you're right. Okay, at this juncture in Mr. Avery's case, all of the prior reasons for holding the legal proceedings outside Manitowoc no longer exist. That's the part you meant. Tell I didn't read all the way to the end. Well, I would assume that means that none of the judges that were involved in his original case are there anymore. I don't really know exactly what she means by that. I would probably have to see the motion from a long time ago when he originally substituted for a judge. Now, he did substitute for a judge after Judge Willis, but they gave him Judge Fox, who, as everybody knows, it was Brendan's judge. So that didn't really make a whole lot of sense. And so then that's when he ended up with Judge Suckowitz. They moved outside of Manitowoc County and gave it to her. So maybe that's all it was just that he didn't feel like there was a judge there that wouldn't be biased against him at the time, and that's no longer the case. Well, I wish I was that confident that there wouldn't be anybody biased about him, but she has her reasons. So I was surprised about that. I thought that they'd move it like to Fond du Lac County or something that's further away from Manitowoc. That's the furthest south of the counties in that district. And I thought that maybe they have a better chance there because it's just a little further away. But we'll see what happens if they put it back. Maybe she thought that would strengthen her argument to get a new judge, is to put it back in the original county where it belongs. So maybe she's thinking that just strengthens her argument to get it out of Judge Suckowitz's hands. I love you too. Thank you. Okay, so then while I was reading this, I'm sure most of you noticed, we had never seen the full order from the Court of Appeals ordering what was happening with this remand. Now, as most of you remember, I was actually in Manitowoc when this happened, so I didn't get to really answer a whole lot of questions or anything about it. But when they first posted it on the docket, and again, I don't have the exact wording right now, but they had said that Kathleen could present a supplemental motion to present information about the CD or any new evidence. And I talked about this quite a bit in my previous video, where I said that I was just confused by that because it said or other new evidence. And then, so I had posted about how this was Kathleen's chance to get in all of her new evidence. It can all be evaluated, and that if the judge ruled now that some of those new things had merit, that the appeal could be dismissed. That was my thinking. Well, then Kathleen had tweeted something about they're going to evaluate the CD, and then we're going to head back to the Court of Appeals. And then she said she had a quote in an article too. And I was really confused. And a couple other people on my page that are involved with legal stuff, they were confused as well. They just said, why would it say other new evidence? And I was like, maybe other new evidence regarding the CD? I don't know. But it really confused me. And then I felt bad because I was like, great, now I have to correct myself. So I went and told everybody, I was like, hey, based on Kathleen's tweet, maybe I'm wrong. Maybe she can't present the other new evidence. And that's why I spoke a lot in my video about how that didn't make sense to me. It just didn't. I didn't understand it at all. Well, reading this order, kind of reinforces what I thought was originally going to happen, because they say a couple things in the order that wouldn't make sense otherwise. Because if they were just going to deal with the CD to see if it will be supplemented to the record, one of the things that Kathleen had put in a footnote, it says the Court of Appeals states, in the event Avery remains aggrieved, the circuit court clerk shall retransmit the record, blah, 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 and the appeal will continue. If Avery is afforded relief pursuant to his supplemental post-conviction motion, he may seek dismissal of the pending appeal. That's exactly what I said when I first posted. So it was a little weird to me, because if it was just evaluating whether the CD could be added to the record, there would be no option for relief. You wouldn't be getting relief from that. That's just a procedural issue. It's not ordering an evidentiary hearing. It's not evaluating anything or anything on the merits, really. And then I thought, well, maybe it's just the Brady violation that's attached to that, but that doesn't make sense either, because she's already presented that Brady violation in her motion for reconsideration. So the only conclusion I can make is that she will be filing more of her new evidence, hopefully. So that kind of threw me for a loop for a little bit there, because here I thought that I read it right, and then I thought, oh, must have had it wrong, and now I'm thinking, well, maybe I do have it right. And I'm just going to say, don't hold me to anything, but I'm just going by that one part where it said that if he's afforded relief and they can dismiss the appeal, they can do that. And I don't see why that would be an option over only a motion to supplement. It's not. You know, that's not relief that would dismiss an appeal or give him a new hearing or give him anything. I mean, technically, I guess they could hold an evidentiary hearing on the CD alone, but I still wouldn't, like I said, that wouldn't grant him instant relief. That's just evaluating if a certain piece of evidence can be added to the record. I don't know, I might be the only one that thinks that way, but a couple people actually did comment saying, wait, the same thing, like, wait a minute, that doesn't make sense. And I was like, I agree. So that's what I'm hoping it means. So that means that when Kathleen files her motion, her supplemental motion, that hopefully everything will be in there, and then everything can be included in the appeal all at once if it gets to that point. Ideally, you know, the judge would find something in there that she does think grants or warrants an evidentiary hearing, and the appeal could be dismissed. Although I'm not sure you'd really want to dismiss everything on all the other charges or the, you know, things she dismissed, but I'm not even going there right now. Okay, so I think that's really about it for that. I didn't really read through the whole order, but I mean, that was the bottom line of what I wanted to get to. Okay, are there any other questions? I think I covered everything I wanted to. I mean, it was pretty quick overall. I'm doing better at being quicker. You guys are asking just a lot fewer questions. Am I aware of what's on the CD? Well, I mean, it's in the motion. It says that there's 6,500 violent images and 2,500 search words of all sorts of bad things. But it's sealed, so no, we wouldn't see the actual images, which is good in my opinion. I don't think anybody needs to see that. Okay, any other questions while you guys have me here? Because otherwise I'm going to go off the air and then you guys are going to all ask me a bunch of questions. You guys are taking it easy on me tonight. Maybe it's because it's early and there aren't that many people. There's only 30 people on. So maybe that's why. Because that one night I did the video and I had 490 comments and I couldn't keep up. No. Hopefully everybody's enjoying the nice weather. Well, here it's nice. Okay, well, hopefully there aren't any other questions. And I can already tell you I'm going to forget something I wanted to mention. I always do. So KZ can submit new evidence. This is the thing, I'm not fully committing to it, but it certainly sounds like it. I mean, that's what I thought it sounded like to begin with. And again, I don't know why they would be talking about granting him relief if it wasn't, if he could, she couldn't do that. No, but you can bring me some. So, is there anything else? I have so many notifications piled up, so I really apologize for that because I have been reading case law all day. And I said I did really try to find some, and I said somebody was incredibly patient with me and digging as much as could, and I could not find a single case of a 97406 motion along with the judicial substitution using either statute. They have to exist, I would think. I can't believe this is the first time that this specific situation has happened. But, everything in this case ends up being a little weird. So maybe it is the first time it's ever happened. I don't know. But I did really try, and I'm kind of burnt out on it now. So I'm kind of done for a couple days. And I don't know if I'll be doing another video for a week or so because my laptop is not working right, and I have to send it in. It's another reason why I wanted to do this one tonight, because I have to send it tomorrow, and it said it could take 5 to 10 days. So I'm going to be without my laptop. I'm so lost. I have an old one, but it's slow, and that's why I don't know if I could do a video. If I did really want to do one, I'd probably use my iPad. Okay. Any other questions? Going once? Going twice? Okay, then I will. Thanks, Jamie. Then I will talk to everybody soon. Bye.